either a very timely panel or a very late panel, depending on how you're looking at it, because the Federal Trade Commission's new rules on the Children's Online Privacy Protection Act go into effect on Monday. So we're going to offer some compliance tips and tricks and thoughts, but you'll have to implement those quickly if you hope to meet the Monday deadline. Before I dive in, I wanted to introduce the panel members here. We have Shair, who is the founder and president of the kidSAFE Seal program. And kidSAFE Seal is a fast-growing safety certification service and seal program that's dedicated to children-friendly websites, mobile apps, game sites, educational sites, pretty much everything. And many well-known brands use it: Cartoon Network, Fantage, Jumpstart, Pearson Education, and Savin Brands. And Shair is also an experienced consultant. He's a certified information privacy professional and a former attorney. I don't know what a former attorney is.
No.
Okay.
Just not practicing in capacity.
Fair enough. With 13 years of experience developing and implementing compliant privacy and data protection programs for large companies, including many Fortune 500 companies. We've also got two Jennifers on our panel. We've got Jennifer Sanders, who is currently working for Paragon Legal with LinkedIn. And prior to that, Jennifer spent 3.5 years as Senior Corporate Counsel, Business and Legal Affairs for Nickelodeon Kids and Family Games Online Games Group. And she supported privacy and marketing functions for enterprise companies for over a decade. And she's currently getting some very hands-on education. She is working with high school students, coaching a Marin High School mountain biking team, and apparently has the scars to prove it. So. And Jennifer Hanley is the Director of Legal and Policy for the Hanley Online Safety Institute. And she's a magna cum laude graduate of the Catholic University School of America, Columbus School of Law. And while in law school, she served as a Vice Chancellor on the Court Board and Vice President of the Communication Law Students Association, and held internships with FCC Commissioner Michael Copps, with EchoStar, and Comcast. And helps now implement FOSSI's global projects, initiatives of government outreach, and things including online privacy, mobile safety, cyberbullying, and sexting. So, all very exciting stuff. So, one thing that we wanted to make sure that we did is make this really interactive and touch on the topics that you actually want to hear about and that will be interesting to you. So essentially, we want to know what your level of expertise is and what side of the divide you're on. So for example, how many folks here have heard of COPPA, maybe grappled with the rules a little bit before, but you wouldn't consider yourself a real expert? Okay, so a lot of the folks here. How many folks have read the FAQs that came out, maybe been to a CLE or two? Okay, good number. And how many folks here are absolute COPPA gurus and should be up here with us, but we came here anyway, hoping you might find something new? All right, no one we have to keep an eye on, I guess. Or no one wants to admit it. So as far as sides go, how many folks here come from the side of children-directed websites or online services, things that are targeted to kids? Okay.
Or maybe perceived as that.
Fair enough. Fair enough. And how many folks are more of the general audience website plugin variety? Everybody else? Okay, so that gives us some sense of where to target things. And given that we have some newbies in here, I thought it made sense very briefly just to go over the basics of COPPA very quickly. In its most basic form, and there are exceptions and exceptions to the exceptions, but essentially if you have a website or an online service and you're an operator of that, you need to provide notice to parents and to get their consent before you collect or enable the disclosure of personal information from children under the age of 13. So that's a pretty loaded statement. I'll unpack it just a little bit before we get started. So website or online service. COPPA applies to a wide range of things. We've got mobile apps, online gaming platforms, internet-based location services. So it's not just, I've got a website and I need to worry about COPPA. Child, like I just said, is someone under the age of 13, so 12 or younger. Shair mentioned whether your website is directed to children. It's a complicated test that's not always clear, but the Federal Trade Commission has put out a number of factors that you can consider, things like the subject matter, video or audio content, the age of the models on the website, who your intended audience is. Personal information. This is actually quite an expansive category. Somebody at the last panel had just said, I can't think of any context in which an IP address is considered personal information. Well, under COPPA, it is, actually. So we'll get into that a little bit more in some of the new rules that have expanded the definition of personal information so that it can potentially apply to a wide range of things, ad networks. As far as notice, there are a couple different kinds of notice. You've got your website notice that, like your normal privacy policy, but there are additional aspects that you have to include to be COPPA compliant. There is a direct notice to parents that often has to be given, and you have to get parental consent prior to collecting or disclosing personal information from kids, unless an exception applies again. There are a number of exceptions. And then one thing that will be really interesting to a lot of folks here who are on the general audience side of things, so your website or your online service isn't targeted or directed to children, but you still could have COPPA obligations if A, you later get actual knowledge that you have collected information from the child, so a concerned parent writes in, or emails you because they saw their kids post in a chat room, or if you have actual knowledge that your plugin or your ad network is on a website directed to children. So even if you yourself are not directly targeting them, if you're plugged into a site that does, COPPA can apply. So these are the topics that we'd like to get to today in some form or another. We're not going to get to all of them. So if there's something that you really want to hear about, shoot up your hand and our very knowledgeable panel will tackle it. So the first topic that's causing a lot of consternation for people is this expanded definition of personal information under COPPA. It includes a lot of things you think of, name, social security number, that kind of thing. But the FTC added 4 new things to the definition. One is geolocation information that's sufficient to identify street name and name of city, town. I hesitate to call that new because the FTC made it clear that what it was really doing is just interpreting what the rule already is. So if you've collected that information before, you should be in compliance right now. Photos, videos, and audio files that contain the child's image or voice. That's a big one for a lot of apps these days, and I'm going to hand it over to Shair to talk about that in a second. Screen names or usernames that function like online contact information, meaning if you have a screen name that's somebody's email address, for example, or something that's similar, and allows you to contact the child online, that's personal information too. If you're collecting it, you're going to have to provide the COPPA protections. And the thing that's got everybody up in arms is this persistent identifiers. Things that you can use to recognize a user over time and across different websites and services, or sites and services. And the and is very important. You have to have both. So this means IP addresses, cookies, device IDs, anything that can fit into that category is going to be cause for consternation. So Shair, why don't I hand it over to you to talk about, I know photos is something that's really been an interest.
Sure. And actually, I'll touch on the others briefly too. So geolocation, I'm going to try to take the abstract now and apply it in practice. Geolocation information is often collected for a mobile app. Okay, so if the mobile app wants to capture geolocation and it's precise enough that it identifies coordinates on a map that allow you to identify the location of a child, that is regulated by the COPPA rule, the updated COPPA rule, and would require a parent's verified consent before you collect that. But that's not the only application. The other scenario where geolocation is being collected, which I'm learning from many of our members, is inside analytics tools, mobile analytics tools. So a lot of the mobile analytics providers out there have the capability, in addition to tracking usage data within the app, they also have the capability to link that data to, again, a precise location. So that becomes important, especially for those of you who are on the service provider side of the spectrum, to understand that can be triggered by the COPPA law, and kids companies have to worry about that. If the geolocation is coarse, is general, it's a zip code, it's a state and country, it's a city and state, but not more specific than that, then that would not be regulated. So that's important to keep in mind. As far as photos, videos are concerned, so the previous version of the law considered a photo personally identifiable only if it had some other data on it that would suggest that this person is Shair Samet. So for example, if I uploaded a photo along with my name, or along with a t-shirt of which school I go to, that would be considered personally identifiable and require parents' consent. The new law does not require that level of detail. Simply the face and image of a child would be considered personal and require parental consent. Now there are lots of apps out there for kids that allow them to take a snap a photo, integrate it into the app, decorate the photo, and then send it off to family and friends. That activity would require prior parental consent. And as I'm sure Heather will talk about, what are the methods of consent? None of them are easy. None of the methods of parental consent are easy to execute, especially in the mobile space. And then lastly, on the persistent ID side, these identifiers have to be used in accordance with that definition to be considered personally identifiable. And there are exceptions, such as contextual advertising. If you use a persistent ID for contextual ads, that would be okay. Contextual ads being ads which are shown based on the context only, that's being viewed based on the page or screen that's being viewed at the time, as opposed to behavioral ads. So there are some exceptions to when persistent ID can be used without running afoul of the law.
And just to follow up on what Shair was saying, the FTC is treating each of these things a little bit differently, as they're new. But if you were previously collecting the photos or the screen names and stuff, you don't have to get rid of all of them. Geolocation is one where you need to go back and you need to get consent. Up until Monday morning, or 12:01 on Monday, if you were previously collecting these, you'll be okay. You just have to give the notice and get consent after Monday. However, as a best practice, the Commission is recommending that you go ahead and notify parents that you have collected this or will be collecting it, and get the consent going forward.
Well, it's also to persistent identifiers. It's also if you continue to collect those things. So if your service or site is already set up to do these things, which identifiers, it's probably going to be recollecting information. So if it uses that information again, recollects it or combines it or uses it to track you starting when it's going to effect, you have now triggered it, even if you collected it originally to put a law into effect. So it's watching what uses you're doing going forward, even if it's, if you take the photo and do anything new with it, now you've touched it.
The screen names too, if you associate new information you collect with those, then that can be triggered retroactively too.
On the persistent ID side, also you need to look at your analytics tools, whether it's Google Analytics, on the mobile side, Flurry, Localytics, Mixpanel, Contagion. All of those players have different platforms and have different solutions, some of which leverage the device ID, and then some of them may be linking that data, the analytics data, to their advertising data, which again could be problematic under the new framework of the law.
And just as a compliance thorny challenge issue, with the mobile apps, oftentimes people download them and pursuant to a certain privacy policy, and you can create a new mobile app, an update. But what happens if people do download it? I mean, how are you supposed to comply in that context? Is there a way?
Well, so I posed that very question when we did a webinar last month. We had someone from the Federal Trade Commission, the new COPPA enforcement team, on the phone and posed that very question. And her answer basically was, if you make good faith efforts to offer a new update to the app, and which is COPPA compliant, then to me, she suggested that they would not view that as problematic. They're only expecting you to do as much as you can, and you can't force someone to install an update. Now with the new iOS 7, I think that changes, because Apple will automatically place updates for apps that you have installed on your device. So just an FYI.
So and what about locational information? So, we are all familiar with the pop-up that pops up on our screen when something's looking for our location. But how do you integrate that into the pop-up context? Where do you want the parent to be?
I mean, to that point, like a lot of people, it depends on how big your companies are and what you're doing. And I know that coming from a big company on my side, even working with my small business teams, and being fairly aware of what they're doing, a lot of the marketing is implementing Flurry chart with these guys. I might end up negotiating a contract downstream. We weren't even using it. Or what are you using it for? Can we back that out and make sure you're not targeting advertising? Is it, depends on what you do to trigger it. So the other one is, as you say, a lot of this information has been collected, and it depends on what you do going forward. And FTC is going to look at best practices. But I mean, if kids got an app downloaded, they're going to press. They're the ones that are going to go in and press download. Update the app. The parent again isn't going to see this. So, or maybe not. It depends. It depends on how you do it. So you're looking, and that's probably why you guys are here to talk about the gray areas in this and what should you be aware of.
The solution is not to collect it or keep it local to the device. So all of this discussion that we're having is only problematic if you upload the data back to your servers and capture it and store it in some capacity. But if you leave it local on the device for other reasons, I'm working with an app that is basically a newspaper magazine for, it's a digital magazine for kids. They ask for geolocation so that they can show, relative to where the child is, where the story is. So if they're writing about something in Denmark, they can show you're X miles away from that location where the story is written about, but they keep that local on the device. They don't upload it back to their servers. So if you don't collect the data, that's fine too.
And the location is key with the photos as well, as Shai was saying earlier, that now the photo containing the image of the child, and do remember that it's a photo uploaded by a child. Mom and dad can upload pictures of the kids, but if it's a photo that has the image of the child or the audio file, you're going to need to either blur the face, delete the child, and you need to make sure that that location information is being deleted as well, if there's any metadata attached to the photo.
Yeah, a lot of people don't know that when you take a photograph, sometimes various digital cameras put the location in there. So that has to be strict as well. All right, so we've talked about this a little bit, about the definitional changes and whether you need to go back and delete things, so we don't need to belabor that. But this is a limitation for the persistent identifier application here. Obviously, people are very concerned because nearly every website collects IP address or does types of analytics. But the FTC has made it clear that when you collect just a persistent identifier, you don't link it up with other personal information, you don't have to get parental consent or provide notice, as long as it's used for the sole purpose of providing support for the internal operations of the website or service. So the list for support for internal operations is up here on the slide. Shai mentioned serving contextual advertising, but definitely not behavioral advertising. Don't get those two confused. And maintaining or analyzing the function of a site or service, the FTC has interpreted that to allow you to use website analytics. So to determine how many people are coming to your site. Sorry, go ahead.
Do you have any idea what the line is between contextual and behavioral advertising?
Well, it can be murky, but contextual is generally based on what is on the site that you're looking at. So some people consider searches to be a contextual advertising. I think most people do. Where, if you search for something, then you can be served an ad based on that. That borders on the behavioral territory a little bit. Behavioral, more in the context of what you did on other websites, what you did on this website in the past, linked up to what you've done on other websites. I don't know if folks.
I think your point is, it can get, I agree it can get murky, and I think these are areas where you're just going to have to use your best judgment. I think that kind of a theory or a rule of law that was used in the keynote this morning was, look, when we're doing all these things to get around the law, you're clearly trying to violate it. So the contextual would be, okay, you're on the door Explorer game, so we're going to serve you girls' clothing advertisements. But then if it says everyone that went from this spot to this spot to this spot to this spot, and that group gets much smaller, because now we get this ad, now you're kind of getting a lot closer to behavioral, if not in behavioral. I mean, how small is that group?
It seems clear that clear behavioral would be like across an ad network, across the internet. Okay, that's behavioral.
Yeah.
Probably pretty clearly contextual would be your single search query here, that's context. The specific case I'm thinking about though is like, what if you remember your last 5 or your last X number of search queries to serve an ad on that first-party site only?
Well, it has to be, it has to be the twofold criteria. It has to be over time, which is what you're describing, and across different sites and services. Now, the FTC, when we lobbied for, in response to the FTC's changes, we asked them to put in the law different unrelated websites or services, but they were not willing to do that. So it's not entirely clear what different means.
I mean,
Well,
how
if
is,
the
how is-
relationship is clear, right? If
As
the
long as there's
relationship-
right.
Yeah,
If
if
there's
there's a clear
affiliation.
relationship,
but
yeah.
I mean, how advisedly are they using that and to really mean and not logical or, and how much would you pin on that?
Well, I think if it's just one website, though, it would be hard to argue that it's across different.
I mean, I think an example of
But if they sort of meant, if they meant that and to mean
It's a
or,
pretty strong
then,
ad.
Yeah, I think it's a strong, I would agree with that, yeah.
And then also, I think, they've referenced their materials outside of COPPA, like the principles, the OEA principles that the FTC put out a couple of years ago, where there is a definitional distinction between behavioral and contextual. So they're, I think, looking to that document as the basis for what's considered behavioral versus contextual. But you have to look at, take Viacom, for example, right? Maybe it's that example, you'll tell me. But they've got many websites across many different brands, right? What if they're tracking across, what if they were tracking across all of the different Viacom brands?
Or many websites within a brand.
Are those different websites? Well, if it's all across Nickelodeon websites, maybe those are affiliated. But what if it's Nickelodeon and MTV?
And the connection isn't clear necessarily.
Does every consumer out there know that they're both owned by Viacom? So the FTC has indicated that if the affiliation between sites or services is clear, then they would not treat that as different sites or services. But
And this is where it's so essential, I think, at this point in time, especially before Monday, but even going forward, that you, if you're a child-directed site, are really talking to, the ad networks that you're using and others, and making sure that they're clear, about the type of services that you offer and about the type of ads that you want running on your website. And really, if you're able to contextually specify for just contextual, that's where you want to go.
I would just add, I see Google on your badge. I would add that I think it's crucial for Google in this capacity to make it abundantly clear to those people using Google Analytics, those people using Google AdSense, to know how do they turn off the behavioral aspects of the advertising network. Because it's not always entirely clear. I mean, you guys word things differently. There's interest-based ads, there's retargeted ads. And this is one of the things I get paid to do. Is, go into Google and turn this off, turn that off, but it's not always so clear.
It's not clear, and we were just talking about this, there's commercial implications as well. I mean, as you talked about earlier, it's like these services are free because they've been paid for by advertising networks. And contextual ads probably make a lot more dollar value than behavioral ads. I mean, there's a lot of implications here.
So I think that what Jennifer Hanley was saying brings us to the next slide here about strict liability for child-directed websites and services. And this is causing a lot of heartburn for folks. Because essentially, if you're a child-directed site, you are going to be strictly liable for what other people are collecting through your website. Even if you don't know about it, even if they don't share it with you, you have a duty to investigate and find out what the ad networks are collecting, what plugins, what, all the things that are on your site. So I thought it would be interesting to hear from you guys about how people are trying to comply with this in practice, and how are they doing this investigation? Are they doing this investigation?
Well, and I'll start briefly by saying this is the #1 question we get right now, is how do we keep Facebook Connect, how do we keep the Facebook like buttons, the Facebook share buttons, the Google login buttons on our website? And the short answer is, can't. The short answer is, if your site, well, it depends, really. It depends on who exactly your website or mobile app is targeted to. If it's exclusively targeted to children, then you really have to get rid of these functionalities, because today, Facebook, for example, does not have a parental consent mechanism built in. And therefore, when you activate a Facebook Connect button, or a Facebook Share button, or a Facebook Like button, Facebook is capturing some data. You don't have to receive that data. If it's being collected or captured through your website, you're on the hook, and you're on the hook for strict liability. They're not, right? You know, Google and Facebook, that's some good lobbyists working on this. They have to have actual knowledge. They need to know that their functionality is on a kid-directed site. But unless they know that, they're not on the hook. So I mean, there's very little flexibility here unless you're a site that's targeting older users, you know, mixed appeal site, where you're targeting some children as well as older users. Then you have some flexibility to age screen, and if someone tells you they're under 13, not allow them to use it, if they're 13 or older, to use it. But there's very little flexibility here.
I just need to build in that one exception for when you have a plugin and they age screen and they're only, but
That's
unless
a
they have
fair
to
enough.
permanently, and you have to permanently click on it, but they have to
How does that
age.
work? How does that work? I mean, I'm not even sure how that works, because what if, it says that if there's already a relationship between the user and Facebook, right, which means that someone already has a Facebook account. But what if they don't have a Facebook account? How does that exception plug in, you know, work?
Right.
That's the uncertainty. I don't.
So the exception here, there are a couple of FAQs, by the way, on the slides. We thought these would be helpful to you too when you go home. So the FAQs are references to the FAQs that the Federal Trade Commission put out recently that discusses these in some detail. There's still a lot of unanswered questions, but the exception in notice and consent, if the plugin collects only a persistent identifier, the user interacts with a third party to trigger the collection, so maybe clicks on the link button, the like button, or the share button, and then the third party has previously conducted an age screen. But then you have to have, yeah, exactly. So you have to have, but presumably at some point that might be coming if they want to be on the child-directed sites.
And just to follow on to that, that too is we need to start thinking about the fact that child-directed sites may start signaling so that the other third parties are aware that they then have the actual knowledge that they're working with child-directed sites. I think as of Monday though, this strict liability and dealing with plugins is going to have a big impact on what's available for kids online. That a lot of people are not going to want to have as much robust content and kind of the plugins and different interactive features that they had before.
Anyone here from a tablet manufacturing company? Aside from Google? No?
Can I ask a question? I know 13 is some kind of a magical number, but how did we arrive at that number? That age?
It's the bar mitzvah rule. The FTC addresses that actually, I think, in one of their FAQs and in some of the earlier legislative preamble language, basically saying that at the time, which was back in 98, 99, 2000, you know, they consulted with some psychologists, psychologist experts and PhDs, and they arrived at that age as being the age at which the mental capacity is further developed. Now,
They're in middle school still.
at
That's
13?
the worst.
No, it really should be young. I mean, it really should be, it should be younger. I mean, older. It should be older. I mean, 10-year-olds know how to do things.
The thing is, I mean, to your point, it's an interesting number, and it's, I think there's two stated purposes that they give for this, is because these, at this age and below, they're more susceptible to targeted advertising, or don't understand privacy implications. And then the flip argument of that is, well, maybe they should learn. And so, do we really want to protect them? Because they're going to be subject to this the rest of their lives, and they should be the ones that probably have a lot of information to disclose. But it is, and then you've got the whole issue of, okay, but now they're still under 18, which is another rule that we use. Or my friends, I was saying an example earlier, my friend's 6-year-old is sitting there, he's got everything except that little CSC number on the credit card, because he's got the mail with the home address on it, credit card numbers, playing all the games. Dad, what's he asking what a CSC number for? You know, and because he's 6. I mean, give me a break. Or even the kids that I'm coaching. I mean, they're like, Jen, I know the site's for 18-year-olds, but really, come on. You guys know that you're marketing to 12-year-olds.
The reality is, I mean, they did a study recently. Dana Boyd from Microsoft Research did a study recently, and Fozzie, I'm sure, was involved in releasing the study, that the majority, I mean, a large percentage of kids under 13 are lying about their age to get onto Facebook, and their parents are helping them do it. So it's, I mean, the reality is kids lie about their age. They know to lie about their age. And this age screening thing is really just an honor system, which the FTC doesn't want you using if your site or app is really for kids. They want you assuming that everyone is under 13. You have some flexibility if you're targeting older users to use an HScreen, but for the most part, they don't want to see it in some context. And how many companies here are using HScreen for sign up on your website or service? And how many of you only allow those 13 and older? 18 or older? 18 or older. And how many of you are messaging how old they need to be if there's an error, if they're under 13, how many of you are saying how old you need to be? All right, don't tell me that.
Yeah, well, there's a camera.
Exactly.
And state the name of your company, please.
There you go.
So we've talked about this about the actual knowledge standard. So now we're moving away from entities that direct their website or service to children, and those that consider themselves general audience websites or general audience online services. And they actually need actual knowledge. But it's not necessarily just actual knowledge that it's a kid. That's one way. There's also actual knowledge if you are integrated into a child-directed website. So how are these guys complying? What are they doing? And are they withdrawing from the child space? What is there anything we can generalize?
We have some really good.
Yeah.
I mean, I'm finding that the third party, I mean, it's still in the state of flux. And you guys, I'm sure, will have your own feedback, but it's still in a state of flux. Companies are still scrambling to work with their third-party vendors to understand what data they're capturing. But generally speaking, I think the third parties are expressing a reluctance to assure child-directed brands that they're copy compliant, for obvious reasons. But by the same token, the kid-directed brands are looking for those assurances. Otherwise, they have to drop those tools.
So is it the kid-directed brands that are going to do the compliance, or is it the third parties that are going to do the compliance, or is that up for negotiation?
Well, they've got to work together. I mean, it's the solution that has to be copy compliant if they're integrating it, unless there's some customization of the solution.
And this is where that cooperation and really doing your due diligence on the third party that you're using and having really active conversations about the type of content you have and what they're doing with any data they're getting from your site.
Well, this is something that we were just talking about at lunch, because a lot of third parties, even the leaders in the field, the people that you may be dealing with at that company, don't understand how the product works. And now there is a requirement to do a little bit of diligence there, and actually you can't just have them contractually agree that they are doing X and are going to have reasonable protective mechanisms around it. You need to actually do a deeper dive. What is reasonable circumstance? And if I'm using some of the track analytics and possibly serve ads, I want to find out what they're collecting and what are they doing, who are they going to share that with.
And going along with that reasonable standard, I mean, now the obligation is there that you need to make sure that they are doing, having security in place for the information that they're gathering, and that they're a trustworthy service, and that they're not going to have a problem with the information that they're getting from the kids from your site.
Okay, so some of the nitty-gritty here. Social media plugins, ad networks, analytics. How are we integrating these? We talked a little bit about how there is this exception that seems to be like the Facebook share exception. But ad networks, so contextual ads are allowed. You can use IP addresses to cap the frequency of ads. Does someone want to explain what that is in the context?
It would just be, I would assume, if you're allowed to do contextual advertising, if you have the address with that contextual ad doesn't pop out, and again, to the earlier comment from Google, can become a gray area.
Yeah, counting frequency basically means determining how many times to show an ad and tracking the IP address to see how many times this computer system has seen that ad, so it can rotate. And that's totally fine. But it's behavioral, so retargeting ads, those are concerned. Analytics we feel also. I mean, again, as we mentioned earlier, even if you're using an analytics provider, especially in the mobile space, you have to understand, are they linking the analytics data to geolocation? Or are they linking it to their advertising network, which becomes problematic.
And so it's important to note too, for the other side of things, that the analytics provider too can rely on the for the internal operations of the website or service too. So you can share it with an analytics provider, for example, but it just has to be limited to that website. The analytics provider then can't go out and compare it to a bunch of other websites. So we have a question on that.
How specific your parental consent and notice complicated? Is it something where you can, in aggregate, say, I opt in social media plugins, or is it, Facebook by Facebook, or?
I'll let one of you
Yeah, I was
guys
just gonna say,
tackle
the
that.
new rule is really specific on this, and so you are gonna see, notice requirements are gonna need to be very, very clear. What the FTC has said, and they make it very clear in the FAQs, that you need to identify all of the third parties with which you're sharing the information. So you can do it in, I think, a link form, but if the list is too long to put in your privacy policy or in the notice there, but you need to make sure you're specifying where that information is going.
But that's not consent, right?
No.
So with respect to the notice, so you can put the contact information for every single entity that collects information through your website, or you can delegate one that's going to serve as sort of the contact person for all. That's with respect to the notice. As far as the consent goes.
As far as the consent goes, I mean, the law has a general standard that the consent must be reasonably calculated in light of available technology to ensure that you're gaining consent from the parent of that child. Now, that's the general standard. The law also lays out specific procedures you can use to gain consent. And when I list them for you, they're almost laughable. One of them is credit card transaction. And by the way, for that, the iTunes password is not sufficient.
Yeah, that's
Okay. 2 is you get on the phone with live trained personnel, either on the phone or video conferencing, which is extremely costly and not scalable. 3 is a printed, signed, physically signed consent form that the parent scans or faxes back to the operator, which is basically the parent, which is basically obsolete. Right?
These kids don't know how to use fax, right?
Well, maybe that's a good solution.
They the recipient of it, we're just like, oh, that's not going to work. We can track that stuff, right?
Yeah,
And again, it's
yeah, and then you can also use more sensitive data like social security number, the last 4 of a social security number, or driver's license, which nobody wants to do because of the sensitivity of the data. And then there's also an email-based mechanism. Don't get too excited because the email-based mechanism is limited. You can only use that if the data that you're collecting is not being shared in a public forum like a chat or community message board, or the data is not being shared also with a third party like Facebook. So for the Facebook functionalities, for example, the email-based consent wouldn't be sufficient anyway. So there's really a limited. Now there are several companies, including ours, who are working on some innovative solutions to address this problem. We're not there yet. So in the interim, I think you're going to see a lot of companies just get rid of this. But just an opt-in, hey, get your parents' consent, never sufficient.
right. And what Shair is talking about is the email plus, which is up here as the 4th bullet. The FAQs are helpful in understanding what that is and how it operates. One of the things on this list too is sites and services can participate in an FTC-approved safe harbor program. And I know Jennifer Hanley that you.
So the safe harbor programs are 5 right now. The new rule does allow for an expansion of that. There will be, I think, other people putting themselves forward or their organizations forward to become a safe harbor. But there's some real benefits, especially if you're a smaller company working with safe harbors. They can help you with your privacy policy. They help ensure compliance. They can really provide kind of a shield from FTC investigations for you. They have really stringent requirements, but they work through the whole development of your site and can give you the behind the scenes, how to comply with these rules. They have a lot of experts on their teams that can assist you with this. And they do cost money. You have to pay them for the service, but at the same time there's a real benefit to that because you could end up having a real problem if you end up with an FTC violation. It's $16,000 per violation.
And this is one of the areas where the FTC, sometimes they have finding ability, but they have exercised it.
Yeah.
We've seen multi-million-dollar judgments and
huge fines, and the FTC has been very clear that they're going to aggressively enforce the new rule. And so using a safe harbor or making sure that you have an attorney that you're consulting to really make sure you're complying is going to be key for this. Because you not only will you have the monetary damage from the enforcement action, but your reputational damage is a huge deal. And if you are no longer a site that parents feel they can trust, you might lose a lot of your users.
So, yeah, there's a lot going on. I know, Nickolodeon, that was the bigger issue. We were always within a compliant and moderately gray area. The publicity and the cost that we have to deal with around that were huge.
And as an FYI, we'll be applying for safe harbor status in the next couple of weeks.
All right. So one of the things we skipped over was age screening. So Under the prior law and under existing law, general audience sites, you don't have to age screen users if you don't want to, if you're not targeted to children, or directed to children. If you are a child-directed site or service, and you target children as your primary audience, you can't age screen. You essentially have to treat everybody as though they're under 13, even if you know otherwise. Even if you know that someone is a parent, you can't treat them any differently than you're going to kid. But under the new rules, this is something that a lot of folks are excited about. If you are a child-directed site, but they're not your primary audience, so you're also targeted to parents or older teens, you can age screen and treat kids as kids and treat adults as adults. So I thought it would be interesting to talk to the panel about this and about how people are implementing this and some of the difficulties perhaps of deciding what your primary audience is.
Well, I like to call this the Disney rule, because Disney is the company that heavily lobbied for this change, and they were expressly identified in the FTC's Federal Register notice as being the one that was behind this change. But essentially, gives flexibility to sites that are not specifically for kids or exclusively for kids, but may have lots of kids using it, but also appeals to teens and parents. And Disney.com is a good example of that, because if you think about it, Disney.com on the one hand has Toy Story, which my son plays with all the time on it. And at the same time, you make a reservation for a Disney resort on Disney.com, and you buy a theme park ticket on Disney.com. So it's really, it runs the gamut as far as who's using the website. And in that context, they have flexibility to instead of following all the copper rules, ask for an age, and if the user indicates they're under 13, not allow them to submit information or register. And in fact, Disney does do that on many parts of its website. One good example is if you go to the Toy Story site, you'll see they have a Facebook share functionality. If you click on it, it'll launch a date of birth field. I'll ask you for your date of birth. If you're under 13, they won't let you use it. If you're 13 or older, it'll allow you to bring up the Facebook functionality. So that's a pretty good example of how they've executed this loophole.
Well, just to add a little bit to that, in the age screening, I think we could give a few examples in the FAQs. I actually find this rather humorous that they have to give them, so I'm going to assume it's in the
People have done this.
But like in your age screening, if you're just going to pop up a set of years, don't make the bottom one 13 and up. If you do it and they hit this so that they are under 13, they get a number, don't put up a screen that says, oh, you're under 13, you can't come. Like if you usually just shut them out and say, sorry, service not available to you. Don't allow them to just click back and re-trigger it. And in fact, it's probably good practice to attach an identifier so that they can't come back in for 24. I mean, it depends on what you want to do. The business is going to want to say, we don't want to block that computer for 24 hours, but you might want to do that. Or, go talk to your parents and they'll tell you why you can't play this site. I mean, again, 6-year-olds know what this means, right? So try to be reasonable here to be actually age screening in an effective manner.
Right. Yeah, the FAQ does go through the things.
It
does. And they do suggest as a best practice to drop a cookie so that you can't just go back and change your age and go forward.
Question for the awareness of the new rules where you're not directed at children, but they might be there in your mobile app. With you couldn't rely on the iTunes age gate, right? You'd have to do it again for your app again.
What iTunes age gate? The password?
Yeah.
No.
So you still have to do your own.
Correct.
Yeah,
Correct.
they've specifically said that you can't rely just on the app store password.
For any site? Then
For consent purposes.
Or for age screening purposes. And to the best of my knowledge also, I think Apple, if anyone is here from Apple, correct me if I'm wrong, but I believe Apple started to require that in general on kids' apps. Like if you create a parent section inside the kids' app, before someone can access the parent section, you're requiring some form of age screening. I'm also hearing that for in-app purchases within the kids' app, they're going to start requiring that. I don't know if that's a formal policy or just something on here, but
So this is a very gray area. How can a company know if, yes, I'm directed to children, but no, they're not my primary audience? And what are some things that people should be considering when they're thinking about that question?
Well, there's a set of factors. I don't know if you have it up on a slide here, but there's a set of factors that are set forth in the law that you can look at, as Heather mentioned earlier, the age of the models, the subject matter of the mobile app or site. And it's, to most of people who are working in this field, they know whether or not they're directing their stuff to kids. Who is your actual audience? Who is your intended audience? Where are you showing your advertisements? Are you putting your ads up on Nickelodeon's website? Well, then maybe you're directing your app or the site to kids. So there's a variety of factors that you can look at. I guess one area I'm seeing is a little gray. Is suppose you have an app or a site that's directed to very young children, preschoolers, 3 to 6, right? Educational, teaching about the ABCs, basic math, the triangle, shape concepts. So the user is the consumer is consuming the content is so young that they can't register on their own. They don't have the sophistication to register on their own. In those cases, can the operator of that site just assume that if they have a registration, it's a parent who's doing the registration? This is not something that's talked about directly in the law. My position has been that it would be okay if your demographic is so young to assume that you're dealing with a parent on your registration screens. You should still have an age screen, but I think it's fair to say you don't have to assume that the user is a 7-year-old or an 8-year-old and therefore have to build in a whole consent mechanism.
Just a comment, not to nail you on the issue, but have to remember that there are kids who are 4 years old and have the mind of 4-year-old, but there are kids who are 12 years old and disabled, and would be in need for this type of stuff. So it's a difficult judgment to make.
It is. I mean, it certainly is. And I work with many companies who are offering mobile apps and browsers and websites for kids with disabilities or autism and things of that nature. I think everything has to be assessed on a case-by-case basis. But you can make the argument that if you have a site that's for autistic children who may or may not have the capacity to do these things on their own, to direct the registration to a parent and assume it's a parent with an age screen and not have to build in a consent mechanism. The FTC won't tell you that.
Well, yeah, it's going to be, a lot of this is going to be your judgment call as we're bringing up there are gray areas. And again, look at what your site's doing, look at who you're targeting, look at how many, are we doing this whole registration process because 1 or 2 people may do this, or if they're likely to be a greater number. What is the purpose of your site and what other mechanisms within the site, like what other, there are other safety features that you can be implementing in your site so that you have an overall sort of protection plan or mechanism.
And I think that the commission wants to see people making the best efforts, taking these steps. And I think that will show, especially in these early days of trying to comply with the new rule, after Monday, they want to see that you're making the effort now, even if you don't get it 100% right, say July 2nd, that you're undertaking some steps here.
Well, I think Commissioner Oldhausen actually said that, right? That if you're a smaller company and you're trying to comply, that you're not going to get hit on July 1st with an enforcement action.
You can use the prosecutorial discretion.
Exactly. So one important practice point is that if you're a general audience website and you age screen, perfectly fine to exclude people who are under 13. If you're one of these child-directed sites, though, and you employ the age screen to decide whether you're going to treat them as a kid or treat them as an adult on your site, you can't entirely block kids from your site. So if they reveal themselves as being under 13, you have to provide some aspect of your site for them. Just don't collect their information at the consent first for that. So we talked a lot about parental consent. I don't think there's anything else on here necessarily that we need to talk to, other than that the list is not exhaustive.
And one quick best practice, just so everyone's aware, is that you don't just have to pick one of these. So with your site, you can use multiple ways of obtaining the consent. And so sometimes parents might not be comfortable, say, with the new video conferencing with someone. You may want to provide an additional option.
So, and it's non-exhaustive. So there could be other mechanisms that are acceptable through safe harbors and the like. There are some things that the FTC considered in the rulemaking proceeding, but decided not to adopt at this time, like platform-based for the gaming context. Are the things that you guys see as maybe being on the horizon as a possibility, or?
I'm seeing a few. Some of them are based on, back-end databases with some of the big credit bureaus, where they have some unique information about people across the U.S. We're looking at building something in the near term as well. Can't disclose the details on that, but so we are. And I think perhaps at some point Apple might come around and strengthen the iTunes-based system, password system, because that's what most everybody relies on for the download. So why not leverage it? The problem with that is twofold. One is the law requires that there be a credit card transaction, so and that the credit card get charged. Some of the apps are not paid apps; they're free apps. So in that context, it doesn't work. The other problem with the iTunes-based system is that the law requires that you give notice, that the app give notice to the parent of what their data collection practices are. And the Apple system is not designed to do that for you right now. Apple's not in a position to provide notice of what every single one of the apps on its platform is doing with the kids' data. So that was the other problem. What they call a common notice mechanism doesn't exist today. But that could change. For those of you who are interested, we did a survey on the adoption of consent mechanisms and those in the new mechanisms. Around 75% of companies said they're not likely to adopt any of the new mechanisms because of affordability and complexity reasons. And the average cost of obtaining consent per child is somewhere in the neighborhood of $3, given these mechanisms.
And remember, if your app changes its functionality, collecting new information or using it differently, you're going to have to notify the parents. So these are going to be, especially as a new glass, it's going to be tricky. And then also, email plus as an option, just to be very careful where we're using that and how we're using it.
As we discussed earlier, internal use. You can share it in some context with an internal service provider, but if you're sort of sharing it on a public way, or you're sharing it with someone who's going to use it for behavioral advertising, plus doesn't work.
Anyone here from a school? No? School district or working with schools?
So some of the practical impacts of the new copper rules, some folks are really worried that this will affect children's content. What do you guys think about that? Is that a legitimate fear?
I'm hearing it from app developers in particular. There have been a couple articles even just out today from app developers and people who run online games who are saying that, particularly because of the behavioral advertising aspect of it, that they won't be able to continue with it, or they're going to have to put things on hold for now until they have more time to figure out how to comply with the new rule. So I think there will be an impact.
What about states? We've been talking a lot about COPPA and the Federal Trade Commission, but the states can enforce COPPA too.
The states are getting really active on this right now. I don't know if anyone's familiar, but in Maryland earlier this year, they tried to do their own version of COPPA that would have extended it all the way up to 18. They also wanted to mandate that all ads for minors would be clearly labeled as advertisements. The bill was changed a little bit and it's turned more into a working group that's just started, and they're going to be looking at advertising practices for teens right now. But there have been state enforcement actions in the past in Texas and New Jersey, and I think we may see more of these. The states do have the right under the federal rule to bring enforcement actions. I think the FTC gets kind of first dibs at it, but the states can then bring the action if the company or any of the information is collected in their own state. So I think we'll see some aggressive enforcement.
That's a lot in California.
Yeah.
Well, the New Jersey Attorney General sued a California company, which was interesting.
It's a great platform for politicians, right? So it's
Right, who doesn't want to be for kids?
right, and it's the practical impacts. It was in Maryland early last year, I think, with the raising the age to 18. It was a logistical nightmare. We would have to segregate out data from children in Maryland. So we were just kind of shut down the whole activity.
Yeah. And in addition to COPPA right now, here in California, you're seeing some bills dealing with teenagers and advertising overall. So not just looking at the under 13s, but starting to specify what you can and cannot advertise. So things like under 18, you can no longer, if this bill goes into effect, advertise, spray paint, laser pointers, tanning beds, that kind of stuff. So I think we may see other states trying to go in this direction where they're kind of taking on a bigger role when it comes to teens and online privacy.
There's one other area to note that's sort of interesting, because if you look at this on TV in that area, a lot of the advertising is much more heavily regulated. It's based on additional advertising for the time of day that it's shown, how many commercials per hour you can have, or within a half an hour block. And in gaming, they're a little bit behind here, and they're just kind of catching up, so you might want to think about that. But things like advert games, if I've got an online game that had a McDonald's figure in it and a lot of yellow and gold colors, is that an advertisement? It's an advert game, and right now we're calling these games, not advertisements. But that's probably going to become much closer scrutinized. I'm sure it is. And that will be regulated and tracking that mechanism. But again, these are also features that help keep these services available at low cost or no cost to people. So
The good news is that COPPA does not have a private right of action, so consumers can't bring a class action.
I'm a European lawyer at Osborne Stark. We advise US and European businesses on European Union law. So this is a really rare opportunity I get where the standard is being set higher in some respects than the US and the European Union. So this is a question which not many Europeans get to ask, which is, you guys are the experts in relation to COPPA implementation. Most Europeans have no concept at all about COPPA, especially app development, and no concept of app development. So for businesses which are based outside the United States, what's your advice in terms of compliance?
Well, I'll say, she has an international reach as well, but the vast majority of the companies, we work with over 100 companies in the kid space. I'd say a large percentage of those are in Europe, France, UK. There's lots of mobile app developers in France, lots of them with kids apps, and they're actually. We're doing a lot of educational outreach to the community, so they're aware of the issues and they're addressing them. A lot of times, because these app developers are working with brands in the U.S., so they're generating apps for brands, for intellectual property here in the U.S., and therefore they have to be familiar with the issues. But from a legalistic standpoint, if an app developer is based in the European Union, and their app is appealing to kids in the U.S., then they're regulated by COPPA, even though they're not based in the U.S.
And the FTC has made that very clear. They sent out about 90 letters in May to app developers here in America and others, but they also sent out to some European companies saying, we know that you're targeting your audience is some American teen, under 13. And they said you have to comply by July 1st. And so the more the commission, the more the app developers and the ACT and others can get the message out there to the non-US companies, they need to comply as well, unfortunately.
that's a good question. What are the European companies thinking about this right now? Because it's all of a sudden.
Yeah, they're thinking exactly the same as what the US companies thought about implementation of the cookie directive, which is totally unacceptable.
Yes,
there is no work, and so they're thinking exactly.
Has there been any enforcement of the cookie directive?
It's patchy.
And isn't there a European COPPA kind of being floated right now as well between the
France?
Yeah.
France.
Yeah, and it's kind of the same as what's coming along with the data protection regulations, like with that sea change. A lot of people, in practice, especially with small app developers or businesses which don't have in-house counsel, they're saying this is just not something. It might kill the business, but there's not much we can do about that.
Yeah, that's what we're hearing.
But what about with the safe harbor which you were talking about? Is that available to businesses which are based outside the US?
Yeah, they are.
I will add though that since the year 2000 until now, there have been 20 enforcement cases brought by the FTC, millions of dollars of fines. Not one of them has been brought against a company outside the US. So when you're looking at, that's not to say they shouldn't comply.
Right.
But when you're looking at the risk factor of all this, jurisdictionally, I don't think the FTC is really wanting to go after companies outside the U.S.
Hopefully.
There's no guarantee that, unfortunately. Yeah, exactly. Because
Don't rely on it.
yeah, not on wood, right? We are actually at the end of our time, so we won't have a chance to get to security, but if anyone has any questions, by all means come on down. But are there any final questions anyone has? Any takeaways, any last words from the panel?
Concerns? Anything?
sneaky.